I'm John Hood from Moore Kingston Smith, and I'm a tax partner and the head of the tax dispute resolution team here. I thought I'd give you a brief overview on HMRC's powers to recover unpaid tax. Now, the first thing to remember is that normally you have to consider the behaviour that led to the tax being lost. This goes down into three broad categories. First of all, genuine mistakes, where someone has taken care in preparing their tax return but still nonetheless has made an error. Someone who's been careless, i.e. they've not taken reasonable care in the preparation of their tax return, and which has led to a loss of tax. Or alternatively, someone who's acted deliberately, i.e. committed tax evasion or tax fraud. So how HMRC determine which category applies does really determine on the outcome of any investigation that HMRC conducts, and getting specialist advice on how to make sure that you minimise your exposure is really key. One of the things that has been identified is that HMRC nowadays has taken a stronger approach towards the use of the deliberate behaviour category, which allows them to go back a lot further, so they can go back 4 years for a normal mistake, 6 years where there's been carelessness, and up to 20 years where there has been deliberate behaviour. So if you consider that an error may have occurred 10 years ago, if they were to argue that this was deliberate, one, that allows them to recover the unpaid tax, and two, they can charge a significantly higher penalty. So understanding HMRC's powers to recover tax is really key to resolving any tax dispute, and getting the right advice at the right time can really assist you in making sure that you minimise your exposure. Now, normally what would happen is that you need to consider the type of behaviour, and then this involves whether or not there was any knowledge or intent of the error. You know, how you prepared the tax return, or if for example, you didn't prepare a tax return because you didn't realise that you had to, then again, looking at the circumstances to work out whether there was an issue. And there's one other category which you may wish to bear in mind, and that's where someone has a reasonable excuse for not reporting something. So for example, if someone had come to the UK, only been here for a couple of years, and not realised that they needed to report income which arose on assets they had in their home overseas, then that would be another reason perhaps where you could argue, well, was there a reasonable excuse? Normally HMRC say it has to be an unforeseen circumstance. So for example, if someone was ill, or a family member was ill, or they were unable to deal with a matter for one reason or another. But nonetheless, understanding all these categories, making sure you get the right advice at the right time is really key. I hope that's helpful, and hopefully we'll speak to you soon. Thank you.